I will start the recording. While we are waiting for our speaker, I wanted to take a few minutes to go through the data collection assignment that I have asked of everyone, seeing as I am not seeing many lines highlighted. So I wanted to take the opportunity to walk it through with everyone just so we had a bit more understanding. Also recognizing I haven't received many questions. So I'm not sure if there are concerns around this assignment or if folks just have not yet gotten around to it. Regardless, wanted to do a bit of a tutorial while we have the opportunity. So starting here, when you log into the fellowship shared folder, you will see the police department database. And then we have a few options here, all of which need to be completed. So I selected the campus police just for example's sake. What you would do is scroll to where your school is listed and fact check all of the information that is included on the line. In addition to fact checking, you want to include links to where information was obtained, depending on where you found the information. So obviously, in order to do an appropriate fact check, you need to locate the source. Once that source is located, that needs to also be included in column C. So for example, recognizing I do not have a campus, but if I was to do one for the American Bar Association, wanted to include our address, which I think is, don't send an email to this address. I'm not entirely sure that it's correct. I would look up information on how many officers are part of the campus police department. We'll say, for example's sake here, 10, and then the link would be blah, blah, blah. Then amount of hours of training required to become an officer. Again, we'll say 150 with a link. If this information is available, whether or not campus police are armed, that would be included here. Core responsibilities of the police, typically found on their website, that would be included here. If there is a mission or a vision statement, that would be reflected in this box. Approximate budget of the campus police. I have this reflected for 2021 to 2022, just recognizing that's when the majority of the other data was included. So please try to capture the information from that time frame. If it is a different time frame that you are able to collect the information, simply update it in the cell. And then going through line by line, or sorry, column by column. Once all of that information has been checked and links included, then you will highlight that line so that I am aware that it has been completed and is ready for upload. Then if there are, throughout your research, if you identify additional documents that you would like to see included in the database on the consortium's website, create a permalink for those documents and upload them to what is listed as document upload in the shared folder. So that is available here. We want those tagged both thematically as well as based off of which police department the information is in reference to. And I have a tab up here, but can't access it. Ooh. So that information at the end of the semester, once all of that has been completed, that will be added to the repository on our website. So if you have any questions about the types of information or types of documents that we'd be looking for, or questions about how appropriate a resource that you have found might be, I would recommend first checking the existing database that we have created, because it is sort of an interesting hodgepodge of documents that exist here. Also, of course, feel free to reach out to me with any questions. But I typically err on the side of more is more. And so the more information that we can have, particularly if it is already tagged and of relevance or interest to the department identified, then it should be included. All right. Stephen, I see your hand raised.
Yes, ma'am. Just a quick question. When I looked at the database, it had MSP on there, which is the state police. We do not have a campus police. So we are surrounded by the city of Lansing. I didn't know if you wanted us actually to update it with something else, or if the information that was there was okay. I guess that's your call.
No, I think that is fine. What I would say, and I've seen a question in the chat as well. Sorry, just recognize that while I'm sharing my screen, I can't see the chat, so you're better off raising your hand. So thank you, Stephen, for doing so. Let me share this one more time. This information needs to be completed for local attorneys, campus police, civic leaders, courts research, highway patrol, local police, sheriff, politicians, and state police department. So Stephen, recognizing what you've just said, that there isn't campus police, I feel comfortable in omitting that for your school, recognizing this information will be the information from your jurisdiction will be reflected in other areas. Unfortunately, Michigan State is not currently member to the consortium, and so we simply won't have their campus police reflected. It would feel odd to me to have their campus police reflected when they're not member to the consortium. And so I think just not having that line completed for your school is wholly appropriate. And then is it Holly who also had a question?
Yeah, sorry, that was me. I had completed for Metro. I just didn't realize that we were supposed to be doing all of them. So I will go back.
I appreciate that. Thank you. And Holly oh, no, sorry, it's the other Holly. No, remind me of your school, Holly?
Georgetown.
Georgetown, okay. I believe the previous fellow for one of these categories focused on park police rather than highway patrol. So, or maybe sheriffs, recognizing that we don't have those in DC. So that information should be reflected. But if you have any questions, just let me know.
Okay, thank you.
Most definitely. Any other questions about this assignment? How it will be used? Okay. I'm assuming folks are on spring break, or perhaps still thrown by the time change, but perhaps they will continue to filter in as our conversation goes on. But I am delighted today to be joined by Mr. Brandon Garrett. Brandon, thank you for being here. Brandon is a leading scholar of criminal justice outcomes, evidence, and constitutional rights, and is the inaugural L. Neil Williams Jr. Professor of Law and Director of the Wilson Center for Science and Justice at Duke Law, an initiative that brings together faculty and students to improve criminal justice outcomes. His current research and teaching interests focus on evidence, forensic science, constitutional rights, habeas corpus, corporate crime, and criminal law. He is the author of multiple books, and in addition to numerous articles published in leading law reviews and scientific journals. His research and work has been widely cited by courts, including the US Supreme Court. So I could not ask for a more knowledgeable voice to join us for our conversation today. Brandon, we're delighted to have you, and I give the floor to you.
Great. I don't know how these classes go, but it's a treat to see you all. And I'll just maybe say a little bit more about my work on police accountability and some projects that I'm working on right now, and then see if any of it connects or resonates with what you're working on, and we could all talk. I started my career as a lawyer before I decided I wanted to be a law professor, mostly just suing police, and police accountability was basically why I went to law school. I had been doing poverty work in New York City, and my clients were always getting arrested. and I decided that suing police was the way to go. I considered criminal defense and did a little bit of criminal defense work, but really mostly focused my work as a civil rights lawyer. Both of my summers in law school, I worked on a case that had different names and different iterations, but there was a class action that then led to another class action over many years, suing the New York City Police Department over its stop and frisk racial profiling practices. And that was my first introduction to litigation against police and all the challenges of bringing large scale cases to try to end police practices. That litigation had lots of important effects, and I was lucky in law school to get to know Jeff Fagan, who was the expert that had been hired by the New York State Attorney General at the time to look at all the stop and frisk data. And Jeff Fagan's work as an expert and some of the related litigation ended up really exposing how large scale the racial profiling was, how dramatically those stops were focused on Black and Latinx young men, and also how police were pretty openly naming illegal bases for their stops. At the time, they had a forum where you could sort of name your reasons for why you were stopping and frisking someone, and they would often write down reasons that were patently illegal, even under the really broad Terry standard for stopping people. They would name things that were not even reasonable suspicion and were blatantly not reasonable suspicion. So one of the important reforms that they adopted in response to litigation was a form where they could just check one or more of the legal reasons why they could stop someone. And so then they didn't have any of the handwritten illegal reasons anymore. But there was really interesting work that was done in that case, because those forms initially were just on paper. So police couldn't just check off legal reasons, and they had to write things. They didn't always write things, but you really saw sort of in real time police writing reasons that were not constitutionally permitted when they were stopping, at vast scale, hundreds of thousands of kids every year. And actually the judge in that case did something really interesting. I mean, in general, in civil cases, one of the most boring things about doing civil litigation was dealing with discovery. But in that case, the federal judge at the time, Shira Shindlin, ordered that basically all of these hundreds of thousands, millions over years, stop forms that were handwritten by these police officers, that they be digitized so that the plaintiffs could work with those data and do something with it. And that alone, that discovery order, really created data that exposed some really remarkable things about that whole stop and frisk program that the New York City police were doing. And one of the real pleasures of that work as a law student, getting into court in any way was exciting. I didn't realize sort of how boring depositions could be, but I basically was just sitting in conference rooms, and I was very excited to get to watch depositions. The law firm lawyers that I was working with were doing depositions of one after another of the leaders of this kind of elite squad in the New York City Police Department called the Street Crimes Unit at the time. And this litigation ended up shutting down the Street Crimes Unit. They then created other units, but I got to hear about the approach of these aggressive sort of elite cops that would just go around just stopping everyone they could who looked young and who looked Black or brown, and how they made their numbers and what their approach was. So that was my first big introduction to civil rights law, and I decided that's what I wanted to do. And after I clerked, I went to I guess during that litigation, one of the big questions was, how could they get standing to actually enjoin the practices of the New York City Police Department? Because one of the big challenges to relief in this area is the U.S. Supreme Court's ruling sort of many crises in policing ago in Los Angeles versus Lyons, which you may have come across more than once in law school, but it's a case that imposes special barriers to standing if you want to get injunctive relief against government. And it raises special questions about getting standing to sue in federal court a police agency. And although the LAPD was choking people over and over again and killing them in all sorts of police encounters, and although by then in the early 80s, it was commonly understood that holding people in chokeholds could be deadly, the Supreme Court basically said that, every interaction is different. There's all kinds of discretionary decisions when things get hands-on and police officers are dealing with potential danger. And so, you can only get an injunction if there's some policy, and there was no policy that they could unconstitutionally choke people. They just had a policy that, allowed use of force only when it was needed. And so the Supreme Court basically said, unless you could show some kind of a policy or an extreme practice that was unconstitutional or discriminatory, even if there's several people who are choked in similar ways, you can't show that they're connected enough to justify issuing an injunction. So this was a big problem in this New York City litigation. What they had was numbers. So there were hundreds and hundreds of thousands of people stopped every year. But we were worried that the NYPD would argue, and they did argue, that, look, every stop is different. There might be reasonable suspicion here. Maybe you can argue there wasn't reasonable suspicion there, but these are all individual decisions. And so to bring a class action, and then even worse, to try to enjoin and stop us from doing practices, we have no common practice. We just, we send our officers out and deploy them. And if they see something suspicious, then they stop people. And if they don't, then they don't. And so that I spent an entire summer doing was reading every case that one could find on the issue of standing after the Los Angeles versus Lyons case, to find courts that had distinguished Lyons, to say that some patterns of stops were so extreme and particularly raised such a strong inference that race discrimination was at work, that you could distinguish the Lyons case and say that that there is something very special about the people being stopped, that it's not just any member of the public that might fall, into the category of people who might just happen to encounter the police again. You don't presume that people will encounter the police again. But a number of courts said that you don't presume that people will encounter the police again and therefore have standing to put an end to a practice. But it's different if people are being targeted based on race. And so we made this argument that the NYPD was in fact targeting people based on race and ethnicity, and that we had enormous amounts of data to show it. And ultimately, the district judge bought that argument and joined these other courts that had distinguished the Lyons case and found standing to sue for injunctive relief. So that was really exciting for me. I spent a ton of time on the briefing as a young law student, and I ended up writing my student note on that topic, which had the cutesy title of Standing While Black, Distinguishing Lyons in Racial Profiling Cases. And the Law Review published it, and I really enjoyed that. And I kept thinking about that experience even after I left law school, thinking, maybe scholarly writing is something that I like. Maybe being a law professor wouldn't be so bad after all. I then also wrote an article looking at remedy questions in racial profiling cases, because that's what I was immersed in at the time. And I continued to do some academic writing as a civil rights lawyer, and ultimately decided to leave that work and be a law professor. My early work as a lawyer was with a law firm called Cochran, Neufeld, and Scheck. And Johnny Cochran, Barry Scheck, and Peter Neufeld had met each other working on the O.J. Simpson trial, but proceeded to get asked to participate in various high-profile police brutality incidents when the family later wanted to sue for wrongful death and sue for constitutional violations. And so they had worked on the Abner Louima case, the Amadou Diallo shooting, very high-profile police deaths, kind of in the late 90s, early 2000s. And so they'd formed the civil rights firm in New York, which is kind of a new civil rights boutique, and it was a national boutique just working on high-profile police brutality cases, police accountability cases, and wrongful conviction suits by people who had been freed by DNA testing. And I thought that sounded awesome. That was exactly what I wanted to do, is to work on interesting civil rights cases. And so I worked there for a couple of years as a fellow, and then spent another 6 months at another civil rights firm in New York City, just to get a sense of what sort of more of a regular civil rights firm might be like. I worked on a high-profile civil rights trial in Providence, Rhode Island, where a young Black officer was shot by two white colleagues who assumed that he was a criminal when they intervened on a scene and proceeded to, in an untrained way, run out into the open, and then shots fired. Worked on a number of other police brutality cases, also a number of wrongful convictions cases, which sparked my interest in criminal investigations and in accuracy of evidence in criminal cases. Anyway, as an academic, I've done work studying the causes of wrongful convictions, a lot of work on police practices concerning interrogations. I represented, in my time practicing in New York, a number of people who had falsely confessed, including, I guess the best known of them were the exonerated 5, whose experience in the Central Park jogger case has been documented in movies and the like since, but it took a long time for their civil cases to result in compensation. That case also involved problematic uses of forensic evidence, and I got really interested in how so many of the innocent people that I had represented had been wrongly convicted based on forensic evidence and problematic use by police and crime labs of forensics. Before modern forensics, DNA set them free. In the Central Park case, there were these hair comparisons and soil comparisons, which were presented, despite the fact that actually at the time DNA excluded all the youths involved in that attack. There's another case was the second trial I worked on as a young lawyer, was a case where the person was convicted in part based on bite mark evidence, where a dentist came in and said that the teeth matched, basically. And so one of the things I did as a young law professor was to look into in DNA exoneration cases, how do the courts handle the types of claims that people brought when in court they tried to, on appeal or post-conviction or habeas, they tried to challenge the false confession, challenge the forensics, challenge the police practices, challenge police involvement in perjury of informants, police involvement in fabrication of confession statements. These are all people that we now know are innocent, and there's no way they could have confessed using details that only the culprit could have known. So in retrospect, we know that if police said that they were fabricating evidence, because these people could not have known details that only the killer or whatnot could have known. These were innocent people that really, unless the police had widely leaked details about the crime to the community, there's no way they could have known them. And so in general, unfortunately, as I unpacked what happened in these DNA exoneration cases, the cases are really just chock full of different types of police misconduct that led to innocent people being convicted. And that work over a series of different studies ended up being the topic of my first book, Convicting the Innocent. I've since done work looking at drilling down into the ways that forensic evidence can go wrong, including the ways that police work biases the work of even supposedly independent crime lab analysts. Also done a lot of work on use of force, and how the courts have handled the kinds of civil rights claims that people bring when they're the victims of police brutality. And Seth Stoughton and I, who's a former police officer, now law professor, and I dug into the standards of care that come out of the Section 1983 case law that the Supreme Court has set out. That work ended up relating to a set of principles, which I don't know if you've come across, and they're fairly new, but the American Law Institute, which is kind of famous for things like the restatement of contracts or the restatement of foreign relations, the restatement of torts. In addition to their restatements, they also issue principles in areas where really the goal isn't to summarize like law in all 50 states, but the goal is to set out important legal principles that we want the United States legal world to adopt. And the Principles of Policing Project was designed to do that for the law of policing, that police departments, have very little guidance from constitutional law. They may complain that constitutional law regulates them so much, but most constitutional rules are just designed to set out sort of a minimal floor. Like you shouldn't use deadly force in an unreasonable way under the Fourth Amendment, but it doesn't really actually, that Fourth Amendment rule doesn't tell you how to actually train your officers on how to use force, or what should the rules be about when you're allowed to use deadly force or other types of force. It doesn't really say anything useful about how to train or supervise police officers. And so this ALI project was designed to provide principles like that. Actually, the very first principle that we released was the use of force principles, which we think really changed the approach towards how you conceive of defining and regulating use of force. We then turned to a lot of other topics, including surveillance and searches and confessions, informants, evidence gathering generally. Said less about remedies and things that happen in lawsuits. The focus was on police departments and what their practices should look like. But that project is now done, actually. Some of these projects take many, many years. This one took a few years, but actually there was remarkably fast consensus. I think also because of terrible crises in the world and understanding that it was important to get these principles out there fast. They got out there fast, and the American Law Institute approved them all last May. And I think those principles are actually available on Westlaw, and so you can pull them up there. So that was a really interesting project. And more recently, so I taught for a number of years at the University of Virginia. I moved to Duke Law about 5 years ago. And there I founded kind of my dream project, which is called the Wilson Center for Science and Justice now. And we basically do research and policy and some amicus and sort of court-related work, although we're not a clinic, we don't bring our own cases. A lot of that work has to do with police accountability. We do work relating to police accountability in a bunch of different spaces. We certainly file amicus briefs in cases that raise issues of police accountability. We do it when we think that our research and our policy work could make a difference. One role is with me having been appointed as monitor in a bail reform consent decree in Houston, are doing a lot of bail reform work. And it's not directly police accountability regulating work, but a lot of what we've shown in that space is how low-level arrests don't really serve much public safety purpose. We've shown how when they changed from a cash bail system in Houston, that many fewer people would end up in the jail. Most people were required to be released under this consent decree. And so that raises the question, what are all these arrests and misdemeanor cases doing? And we now find that with most people being arrested, but not ending up in the jail, that those cases are mostly being dismissed. And not only that, but with most people being freed and their cases being dismissed, both misdemeanor arrests and rearrests have continued to decline. So this whole approach of reducing arrests and certainly reducing jailing of people in these low-level cases has actually been really good for public safety, in addition to being very good for the arrestee population, which had disproportionately affected poor people and people of color in Harris County. So that raises this question, well, shouldn't arrest policies be reconsidered if these are low-level arrests that actually do harm and don't actually contribute to public safety? Maybe those arrest policies should be reconsidered. We've been looking at similar data here in Durham, North Carolina, which suggests something similar, that most low-level cases are dismissed, and there's a real question whether police should be prioritizing them. We've done some work on the flip end, actually. We just came out with a study at the Wilson Center about 2 weeks ago, led by Phil Cook, a well-known criminologist economist at Duke, showing that in the most serious cases, the Durham police were not focusing enough, that in non-fatal shootings, it was rare for those cases to be investigated to result in arrests, as compared to fatal shootings where there was there's a victim and it would be treated as a murder investigation. We've done a lot of work around plea bargaining and sentencing and looking at how criminal cases get treated and inequities and how they get treated, and a lot of work on eyewitness and forensics and confessions and other police practices. I saw at the beginning of the call that you all were talking about looking into policies of particular agencies, and that's something that I'm very familiar with. It's hard and time-consuming work. I did a couple of projects back when I was at the University of Virginia, filing Freedom of Information Act requests with every law enforcement agency in the state to digest how they were complying with a law that required them to have policies on eyewitness identification. And some did not, despite a statute requiring them to have policies. And a lot of the ones that had policies that were out of compliance with recommended practices. And then I did another round of FOIAs to see whether, in response to a lot of negative publicity from my first study, whether they'd improved. Also did the same as to videotaping and interrogations. We just finished a much more elaborate set of, they call them right to know requests in Pennsylvania, of Pennsylvania agencies. And there are a lot of law enforcement agencies in Pennsylvania. It was about 1,200 agencies, but we filed those requests with every single one, and just did an analysis of videotaping, interrogations, and confessions related policies of all those agencies in Pennsylvania. And we've also looked at their lineup policies and are working on a report describing those results. Another big focus at the center is interactions between law enforcement and people with behavioral health needs. We just finished a big multi-year evaluation of law enforcement assisted diversion, or LEAD programs, In North Carolina, it was a comparison of 4 different jurisdictions that had these programs. They worked really differently in each county. And there are lots of recommendations and sort of observations about how those programs play out in practice, given kind of real world resource constraints and the like. And we're doing a bunch of other work at that intersection of behavioral health and law enforcement. But I've been talking for a while. I don't know if this is a good time for me to just stop and see whether anything I've said triggers any ideas or questions among you all. I'm happy to kind of pause and just answer questions and have a little bit more of a conversation.
Thank you for this. I see a few hands raised. Fantastic, because I also have some questions, but I will go in the order I saw. So Marinike. You're muted.
I'm sorry. My question is really about, or have you ever experienced where there's an obvious sort of like off-book policy, and when you talk to either officers or like your DA's office, they won't like admit to it, but you know it is a practice. So specifically like in New Orleans, when there is a domestic like violence case, like the majority of the time there's an arrest made. And so, and it's so rare for that not to happen. And like we've seen like body camera footage and, you know, dash cam footage, officers like calling their supervisors and supervisors telling them like somebody has to be arrested, like somebody has to go to jail. And then we sat in this lecture with like the DA's office and they're like, that is not a policy, you know, you just don't understand like the circumstances. But I just don't know if you like, if that's something that you've encountered and what you sort of do to say like, you know, this is what, if it's not a policy, it's definitely a practice. And so how do we like address that?
You know, the tools, the levers for police accountability are not great. You know, one challenge is that, you know, if it comes to light in a case like that and someone makes a complaint, there's the question of like, what happens to that investigation? Is there a disciplinary record? And can people see that disciplinary record? Because ideally, if you have an officer or a group of officers who are making frivolous arrests, right? They just felt like the interaction had gone on enough that someone needs to be arrested, right? You want a public defender potentially arresting, and you know, representing someone in another arrest and sees that officer. You want them to be able to potentially impeach the officer and use evidence about that misconduct. But you need the misconduct documented. You need to find out whether there's an internal investigation and it's substantiated, or you need some kind of civil discovery and some kind of airing in a civil proceeding. There have been efforts to pass laws to aggregate and collect data concerning police misconduct and complaints with, and ideally you want them to include unsubstantiated complaints, because plenty of internal investigators and police departments don't see it as their job to work really hard to make a bad record on their colleagues. And, you know, some states have started to pass laws to require that this information be available, including so that lawyers and the public can get access to it. And even if, you know, if an officer is racking up unsubstantiated complaints, that can tell you something, and it's something that you could at least use to try to get relief as an individual if you're arrested by this person and you know, we certainly see in civil rights investigations and lawsuits that you do have problematic officers and entire units that develop these practices where they disregard people's rights. They target people based on race. You have these aggressive units that just feel like they just need to make numbers, and they feel like I mean, they sort of feel empowered and feel like they're doing the right thing when they're doing these large scale sweeps. So, you know, I certainly think that one thing that has gotten some momentum in recent years and needs to be a national focus is to enact laws that require that both substantiated and unsubstantiated complaints against officers, both not just for use of force, but also for illegal arrest, other types of misconduct, anything that might be like police perjury or inconsistencies in accounts, anything that can be used to impeach an officer on the stand. All that information needs to be aggregated and available to public defenders, and there needs to be data available to the public as well. And in some states, there are these law enforcement Bill of Rights and other legal obstacles to getting at that information, or FOIA doesn't include it and the like. And so that whole network of laws that have insulated police misconduct from scrutiny needs to be unraveled. And there's been good progress in a few states, but I think that needs to be much more of a focus in the years ahead. And it's something that, we've been thinking about ways that we can work on. We're working on trying to aggregate police hiring and firing data across the states that maintain it, at our center at Duke. And we're trying to do more to participate in policy efforts to advance this type of legislation. It's the kind of area where we're both, we're both data and individual rights kind of come together.
Stephen.
Good evening, sir. Thank you very much for your time. I appreciate it. And kudos to you. Duke would be my #1 law school to go to, but I didn't have that opportunity because I got to stay where I'm at in Michigan. In any case, I had a couple of questions. I'd love to pick your brain at some point in time, but you had mentioned lower level arrests don't really work. So that kind of goes against the grain of the broken windows theory. The other thing that I noted was you talked about rules and that they don't really speak to use of force. Now, back in 2006, when I went to FLETC, the Federal Law Enforcement Training Center, they were transitioning away from their continuum, and a continuum was really never a policy tool. It was really a training tool. And my question to them was, well, okay, what are you going to transition to? And they said case law, Graham versus Connor, Tennessee versus Garner, right?
Right, that's no standard at all, really. I mean, a continuum is also kind of no standard at all.
Right. A lot of agencies kind of adopted those and they try to make them policies when they're really not. But you had mentioned chokeholds and back in LA, and of course in LA at the time of Rodney King, which was many years ago, kind of the unwritten rule was if you ran from the police, you got a beating. If you fought with the police, you had a neck restraint put on, which did not really come out. I'm interested, because I'm sure you've studied that incident. I'm interested if, my view is that being caught on camera, which is really the first time we had that caught on camera per se. I'm interested if you would say, because I don't believe that catching it on camera was really what started the riots. I really think it was Chief Daryl Gates when he came out and said, oh no, the officers did nothing wrong. They were following policy. Well, if that's your policy, that's a problem, as opposed to what we might say today of, we're going to investigate that and whatnot. And just kind of a last comment to the prior students' comments about policy versus what's actually done, the custom and practice. That's the worst thing an agency can do because it shows mismanagement. When you've got a policy, but you change it by custom and practice and you don't stop and enforce it. So in risk management, something that I do when I go into organizations, say, look, your policy and your practice need to be consistent because it's a worse thing you can do. It's probably worse than not having a policy at all. I'd love to pick your brain at some point in time, if that's okay. Would you be okay if I would contact you later? Because I don't want to monopolize the time.
Sure. Yeah, send me an email. But yeah, there's written policies which can be more or less clear on important topics. And there's some really important topics involving police where they have discretion and do things where they don't even have policies traditionally. Use of force, at least there's an understanding that there has to be something in a patrol guide certainly about deadly force. And then over the past couple of decades, they sort of have these continuums and say, well, there's lots of different types of force. And, the more serious the situation, the more substantial the force that you can use, but often not with a lot of guidance on when can you justify a more severe type of force. But simpler policies would often just sort of refer to Supreme Court case law, which was not designed to train police, and just say, use the force that's reasonable under the Supreme Court's decision versus Graham versus Conner in the moment, with no guidance on how to avoid being in a split-second situation where you might have to use deadly force because you're at risk. And so, much more detailed policies that provide guidance on how to minimize the need to use force are in place, mostly in agencies that are larger, more professional, or that have been sued by the Department of Justice. But even really large agencies, on topics where they don't typically get sued, have no policies at all. And so, certainly I found that, especially before they passed a law in Virginia, like agencies had no policies on how you do a lineup. People get misidentified due to lineups all the time, and there's a lot of research on how to do them right, but they're just sort of, you just put some mugshots together, throw together a 6-pack, show a witness some photos, no policies on how to do interrogations. It's pretty common today, actually. Give them Miranda warnings, tell a juvenile's parents or guardian that they're there, but no particular guidance on how to interrogate people in an interrogation room. They have some quite brutal training on how to coerce using psychological tactics, a confession, but nothing in the patrol guide about how to properly conduct an interrogation. Very rare to find a police department that has anything in their policies about their obligations under Brady versus Maryland to make sure that prosecutors have exculpatory evidence. So there are areas where there are constitutional rules where police aren't, they have no policy on it. Not common to have guidance on how to collect evidence in general and how to do investigations, which you'd think if, investigating at least, the most serious cases is incredibly important, and you have the best trained detectives doing that work. Well, what's in the patrol guide about that? You often very little. Now there are at least more aspirational things from leading policing organizations saying, like, you should be trying to preserve evidence and collect it carefully and have well-trained crime scene people and investigate all the evidence, not just based on your preconceived theories of who might be guilty. But again, not a lot of guidance. Also, not a lot of guidance, though, on this bigger topic, like what kind of quality control do police departments have to make sure that they're actually doing things right and that abuses don't happen. I mean, often traditionally it is sort of like they treat it like an investigation, like other things, and so there might be a discipline and investigative unit, internal investigations, but rare for there to be an actual quality control approach, except in the context of shootings, where many agencies will, have an automatic review, basically immediately after a shooting, and bring in top brass to sort of do a post-mortem to figure out why deadly force was used. But outside that situation, if someone is wrongly convicted, if there's a false arrest, if there is an allegation of racial profiling, there is no automatic response. And in plenty of situations, you can correct the problem. Certainly if there's a false arrest, investigate it, and okay, we dismiss the charges. Like, you can do good things to remedy errors if you catch them quickly. Other types of organizations, people often talk about hospitals in this context because hospitals get sued and developed quality controls in response. There will be all sorts of audits and reviews to check how well the agency is doing its work, because they want to minimize patient deaths and patient complaints and costs. Whether it's costs or deaths or complaints, police don't typically have any group of people who do compliance that are trying to minimize those things. And any corporation, any organization these days has a compliance function separate from just general counsel making sure the organization complies with the law. Police traditionally haven't had that. And also importantly, they haven't, they're not like some private corporation. They tend also not to have those kind of compliance functions that provide accountability to the public. And so, the civilian complaint boards and the like have traditionally been very weak, if they exist at all. And, there are some states where like no agencies in the entire state have any civilian review function, or if they do, it's almost non-existent. There are some larger agencies where there have been rocky efforts to have a more meaningful civilian oversight role. But these are not like regular agencies like law professors have observed for a long time. Regular government agencies where there's oversight, regulations, review, notice, participation by the public, right? These police agencies grew up as an effort to sort of professionalize a quasi-military role without a lot of rules or oversight. I'll stop there. There are lots of other hands. And I'm just going to step away for 1 second because my cat would like me to let it out of the office. Okay, cat.
All right, well, just so you know the queue, I'm gonna do Holly
Okay.
and then Katie. So
Great.
Holly, go for it.
Thank you so much for speaking. Your background is fascinating. I'm really interested in junk science. So these things are admissible, people are convicted based on them, and then we realize that they're completely inaccurate. And you mentioned like bite marks, and you mentioned eyewitness testimony. How, after studying, realizing these things are inaccurate, how do we go about invalidating those? How do we go about changing the narrative, changing law enforcement perspectives on those things? I studied criminal justice and started to notice a shift in how my professors talked about eyewitness testimony and mentioning that it's not really very accurate. But how do we change admissibility and change professional perspectives and also jury perspectives on that evidence?
Yeah, there's a lot to talk about, and basically that would be a whole talk. I wrote a book called Autopsy of a Crime Lab, which walks through all the different ways that forensic evidence goes wrong. And one of the responses to the book, which was kind of neat, was that a foundation gave my center a large grant to kind of put together a public toolkit to walk through in a more accessible way what you can do in a community or as organizers to mobilize around these issues. And so I saw you all were, trying to get access and review some of like campus police policies, and I'd certainly done these projects to FOIA police agencies in a state. No one has ever done that for crime labs, and even worse than police agencies, there are very few crime labs that actually make their standard operating procedures, their SOPs, public just on their websites. It's an unusual thing. It's not required for them to be accredited. Many crime labs are sort of what they call cop shops that are basically, divisions within a police department that may have very rudimentary SOPs and no one ever asks for them. I've even talked to prosecutors who put forensic experts on the stand as part of their jobs, and they've never seen SOPs. They don't know what the standard steps are that forensic examiners are supposed to perform. And often these SOPs don't say much about, for example, how are you supposed to testify in court? How can you express your conclusions? Can you really call it a match or an individualization or an ID? Or do you collect and report data on quality issues or on proficiency or internal validation studies in the lab? Do those even exist in your lab? These labs have sort of skated by without much scrutiny, and that the hope is to change that. And so, we're pushing efforts to review testimony of lab analysts, do FOIAs and other requests to get access to these operating procedures, identify problems with all of this. Some of my early work was looking at those DNA transcripts and showed how, in the bulk of those DNA exoneree cases, although DNA testing set them free, really problematic forensic testimony contributed to their convictions. And that work was presented early on in my life as a law professor to a National Academy of Sciences committee that ended up issuing in 2009 a really scathing report describing how, apart from nuclear microscopic DNA testing, there is no other forensic technique that can reliably connect evidence to individuals or individual pieces of evidence. So whether it's fingerprint or firearms or coroner's investigations or tool marks or any of these disciplines, these pattern disciplines, which are so frequently used, they basically said that the more scientific research needs to be done to assess whether these techniques even have a foundation. That has changed how courts have appreciated these problems. I think what's also helped is the vast number of innocent people convicted based on these types of traditional forensics and their stories, and which I've tried to do what I can to present and to collect to people. I, in my early work, was really disturbed to see how overstated this testimony was about matches and identifications, and no one else could have left these prints. And actually, when I then embarked on doing a whole series of mock jury studies to see how lay people evaluate forensics, we found that actually that kind of overstated testimony didn't actually affect people much. I think basically what we found is jurors already assume that it's a match. They've seen so many CSI shows, but it's actually, there was no connection to CSI shows. I think the people who did not watch those shows had the same preconceptions. People just assume that if an expert describes doing expert work and finding a match, that it must be a match. And whether they call it a source identification or a reasonable scientific certainty, they get the idea. It's basically a hit. But we have also found, or as these studies have unfolded, that people we don't have a problem of people uncritically accepting science in this country, for better or for worse. And people really don't necessarily trust experts in this country. Many people walk into the courtroom with a sort of, so you think you're an expert type attitude. And when they do hear information about error rate studies, which have increasingly been done in some of these disciplines, when they hear about how poorly these experts are tested for their proficiency, where their whole technique relies on their training and experience, so you can give them tests and find out how good they are, and then they learn how they're often given these kind of nonsense tests, which really don't tell you how good they are or how reliable they are. People have increasingly heard about these crime lab scandals. I mean, there've been just about every state has had audits, entire lab shut down. They're now reopening tens more thousands of cases. They've already opened 70 or 80,000 cases in Massachusetts out of both of their drug crime labs being shut down. On this toolkit website that we're trying to create or hopefully have it finished by summer, to create more tools for organizers and public awareness around these issues. We have a map of the country showing all the places where there have been audits of crime labs. But one piece of positive news that I just want to end on, because I could talk too long about this. I think there's just been enough concern with how poorly courts have reviewed forensic experts, considering that the scientific community has said that for many of these entire types of expertise, there really hasn't been adequate scientific validation. We just don't know how good it is. Sort of like, where have been the judges? We're supposedly applying a Daubert standard, supposedly looking at reliability to approve experts. For the first time in more than 20 years, the Federal Rules Committee has recommended changing Rule 702, the federal rule for admissibility of expert evidence. And most states have tracked the federal approach, although it may take any given state, some time to track the new revision of 702. But that revision takes effect automatically on December 1st, assuming Congress doesn't act. And Congress does sometimes act, but these days Congress doesn't act on too many topics. It doesn't seem that likely that they will do anything. The two changes highlight that it is the burden of the party trying to introduce an expert to show that that expert is reliable and meets all the other requirements of Rule 702. The second part of the change gets to this issue of amped up overstated testimony and says that judges can't just decide whether a method is reliable, but judges have to evaluate how the expert reached their conclusions, which I think is also really important. And maybe even equally important is that the advisory committee notes, which Congress doesn't get to vote on, have lots of passages now describing all the concerns with how poorly judges have reviewed forensic experts, mostly prosecution experts, and sort of not really applied the Daubert standard in criminal cases. So there are some good things happening. Courts have been extremely skeptical of firearms and tool mark evidence. We just had I have an article with some colleagues that law reviews are still looking at, digesting about 150 years of rulings in the United States on firearms and tool mark evidence and looking at how the courts have handled them. And the bulk of those rulings are really just in the last 15 years. After the National Academy Report, courts have become really skeptical across the country of this firearms comparison stuff. So there are lots of good things happening and lots of challenges. There's a new generation of forensic examiners that sort of grew up in the era where people were more concerned about the reliability of these techniques. And so you do have younger forensic experts who are much more careful to express the limitations of their disciplines. There's some hopeful things happening, but there's an awful lot of work to do. And it is a policing problem, since most crime labs are run out of police departments or they are funded by law enforcement, and they see their role as doing the tests that law enforcement and prosecutors ask for. They don't independently report to a court. They don't independently sort of work for all sides interested in having a test done. And so it is a kind of a law enforcement control of science problem.
Thank you.
Rebecca.
Hi, sorry, I can't turn my camera on. I'm in just in my school area, but this is kind of a culmination of what has already been discussed. And you had mentioned prosecutors, and as someone who wants to be a prosecutor, how come, at least up until now, prosecutors haven't taken the initiative to make sure the credibility to this extent of the examiners and deep diving into all of the policies as far as how evidence is collected and things like that in the way that you mentioned? And like, is there a reason that it's just changing now? Like, isn't it like that the ethical duty?
I think part of it is like none of us are scientists. That's why we went to law school, or like not too many of us have a science background. I mean, defense lawyers, we're reviewing some transcripts for a research project out of Houston, and it's hard to decide who is worse, the prosecutors or the defense lawyers, in terms of asking any questions that are useful to these expert witnesses. And there's a lab actually that has really interesting and powerful quality controls in place. And the prosecutors could be bringing out that really positive evidence to say, and by the way, like your lab is accredited, sure. But your lab does a lot more than just what a minimal accredited lab needs to do. And tell us about the quality controls you have, and tell us about the blind proficiency testing, all that stuff. Prosecutors never do it. Defense lawyers rarely ask more than a question or two. Like the cross often does not fill up a page. Defense lawyers are like, I don't know, it's an expert. Like, are you sure that you reach those conclusions? Yes. And then they kind of give up. The only case where I've seen an extended cross so far in reviewing those transcripts was a misdemeanor DUI case where someone had private counsel who knew a lot about blood testing and DUI type stuff. But if the defense isn't asking any real questions, putting a witness up on direct, it's just very easy to do that without bothering to learn much about who the expert is or what their work is, especially if there aren't really common Daubert challenges. There's just no reason to dig into that stuff. It's very easy to just do a direct of a witness where you just say, so what are your credentials? Like how long you've been doing it? You've got some evidence in this case. What's your method? What did you find? And just what did you do next? What did you do next? Like, it's not very challenging to do. And if you're not anticipating some kind of an attack from the defense where all of a sudden you're gonna have to read like literature and peer-reviewed studies and stuff, there's just no reason to dig into it and get into that. In addition, so few cases go to trial. And so you may know, there are a huge number of cases every year in Houston. There's like 50, 60,000 misdemeanors. There are about 40, 50,000 felonies, which are not the focus of my bail reform work, but there's like more than 100,000 cases a year. When we asked the lab, how many times do your examiners testify? They're like, oh, yeah, no, we save the transcripts every time we're called to testify for supervision purposes. And they had about 20 transcripts a year, 30, very few. Most cases don't go to trial, certainly, especially actually after these bail reforms. It's now more like 40,000 misdemeanor arrests a year in Houston and the surrounding county. The number of trials each year is like low double digits, like 12, 15. I mean, it's like way over 90% of cases settle, or are dismissed, and most are dismissed. About 2/3 are dismissed, and most of the others involve guilty pleas or diversions. Handful of trials per year. Now, the pandemic also put a damper on trials, but when you have very few cases going to trial, prosecutors really aren't in a position to even talk to an expert witness. They just look at a printed out report, and mostly they complain of, and sometimes quite correctly, of backlogs, and it takes a long time to get a result. But there isn't much need to like spend hours talking to the person to understand how they reached the result. It's just one more piece of evidence in the file, and then cases are pled out, and they figure if there are questions about that result, well, the defense lawyer looks at the report, they can ask questions. One of the saddest things we hear from when I talk to people who work at crime labs around the country is that they often have to keep a dress clothes of some type in the lab because they'll often get told day of that there's a trial. So not even the prosecutor is interviewing them to walk through what they did. I mean, and certainly in civil cases, I was doing police misconduct cases, and we would have a policing expert. You'd spend a lot of time working with your expert on their reports and preparing them for depositions. But in criminal trials, often that kind of preparation, even the most minimal preparation, like talk to the witness and tell them that there's a trial tomorrow and spend an hour walking through the paperwork and that kind of thing, doesn't happen. And so, I mean, in general, lawyers don't have time to prepare as much in criminal cases, and they do get more trials than other types of lawyers. But when you don't actually get cross-examined and you have no reason to really dig into the fundamentals of an expert method, judges just sort of let it in and no one asks any questions, then there's really no particular reason to get educated. And so, where you see prosecutors having to learn more and all of a sudden engage with some of the limitations of these methods are in the places around the country where you have a top-of-the-line public defender's office that is really digging into forensics and litigating those issues. And there are a few public defenders in the country that really have specialized forensics units. And that's also caused the prosecutors to become much more sophisticated and aware of these issues. That's been true in Washington, D.C., because the Public Defender Services has sort of a special litigation forensics counsel type office. In New York, there is that. Bronx, in Los Angeles, the Los Angeles public defender has lawyers that sort of specialize and know forensics issues really well. And that sort of elevated everyone's game in terms of thinking about how to litigate these issues. You know, we try to engage prosecutors in trainings and the like on forensics, but it has almost exclusively been defense lawyers that want to take different CLEs and courses on forensics. I guess because if you're cross-examining, it's actually hard. You have to know the limitations of the research. You have to think about really detailed questions. But often the attitude of prosecutors has been, direct is easy. We don't have to prepare. These are just frivolous attacks. And that judges will mostly swat away. This stuff is just not interesting or important to us. And we will get our forensic experts in for the most part. What's the big deal? Often they've said, you know, these scientific reports, not relevant. And how many of these people were actually fingerprint examiners or firearms experts? And that was actually, although the Department of Justice then created a big commission looking at forensics, which issued some really important findings and rules for federal agencies. The initial response of the Department of Justice to some of these leading scientific reports questioning whether there was any reliability or basis for a number of forensic disciplines, the initial response was, oh, but this stuff is not relevant in court. Because they didn't address legal reliability, they just addressed scientific reliability. And besides, they didn't even address that well, because these are research scientists. They're not, you know, practicing, you know, firearms practitioners and the like. They don't understand what practicing crime lab analysts do. These are just sort of elite, you know, research scientists. So no one should pay attention to them. And again, these attitudes are changing, but slowly.
Thank you. Yeah, I think it's just in my mind. I think even just taking the initiative, and I understand that it still could be extra work, but how much wrongful convictions it would even prevent, or even settling. I know people will settle because of the evidence that's presented against them, but if the evidence isn't true.
Well, even, you know, we've talked to prosecutors' offices that, you know, from their perspective, they should insist that the crime lab give them a detailed report so they could see the bench notes, they can see what the examiner did and what they relied on in forming their conclusions. That as prosecutors, if they're supposed to decide how strong a case is, they can't just be getting like a typical one-page report and that just says, oh yeah, the fingerprints, they match, or the drugs, they're cocaine. Prosecutors should be insisting, they should also be giving discovery to the defense, but first and foremost, they need to see the underlying evidence to know how good their experts' conclusions are, together with any limitations of the discipline and the like. But you know, here and there, when prosecutors have tried to push back and say, like, we need more evidence from you, crime lab then responds, well, we don't want to give it to you. You know, we don't have funding for that. That's too hard. That is contrary to our practices, so too bad. And so there can be a successful pushback, and labs, you know, have often not been receptive to the idea that although they're scientists and they say that they're scientists document their work, they've pushed back at the idea that they should have to document their work in any detail. They sort of say, well, that's just paperwork. You know, if you want to hear everything we did, call us on the stand. But of course, most defendants choose to plead guilty rather than face a penalty at trial. So it's rare that that full documentation and inquiry occurs.
Hey.
Hey, thank you so much. I feel like this talk is sort of the reason I signed up for this fellowship. So it's been a really fascinating and incredible talk. I have two kind of basic questions. One, so you described a really incredible and relatively high profile and pretty high profile civil rights career. For folks who are interested in doing civil rights work, who are interested in practicing in state district court, doing like misdemeanors and evictions and small claims and all, like kitchen table law, what is the path that you recommend to do that well? That's my first question, and I can hold the second question or ask it now.
I mean, in general, you know, most law firms are not big ones, and it's lawyers taking regular sized cases and regular clients. I mean, the challenge in doing that work well is that to make a living, depending on how those cases work, that you have a volume of cases, and it's hard to pay individual attention to your clients. And there have been, particularly in misdemeanor cases, there have been scandals in some jurisdictions where you have lawyers taking lots of misdemeanor appointments, but not really meeting with or communicating with their clients. And so there are those kinds of challenges. You want to work, ideally, if it's a small firm that has a mixture of cases, and so that they really can provide their clients with the attention that they deserve. One really wonderful thing, I only worked at 2 firms, not for very long, just for 3 years. But both of the firms I worked at were tiny, and a really big case might involve 2 associates and a partner, but most cases involved an associate and a partner. And sometimes that was really just the associate. And the nice thing about that was, like, discovery can be burdensome, but in these cases, like, discovery was usually like 1 box or 2 boxes, maybe sometimes 3. Like, there were not very many pages. When something had to happen, like a deposition or something like that, or a hearing, basically I got to do it. And so, it wasn't like my friends at law firms were in like their 5th year, they were so excited that they got to do depositions. Within months, I was doing everything, and had in my first 2 years worked on 2 trials. Like, when things happened, I had to do them because you didn't have these big teams working on things. You had a relationship with your client. You could look at every page that you received in discovery, and you really felt like you understood the whole case and how to put it together, which I found really satisfying. I know there are lots of different ways of being a lawyer and lots of different types of litigation that people enjoy. And that said, there are aspects of litigation that I really didn't like. And I was also lucky in some ways where, it was only towards the end, when I sort of was transitioning to teaching at a law school, that electronic filing was fully sort of up and running in the courts that I was practicing in. And so there were some really nice things about back then, where if motions were filed and they didn't come in the mail at 5 p.m. on Friday, then you didn't have motions over the weekend. And that changed when electronic filing started, and people could file things any time of day or over the weekend or whatever. There was a nice, litigation is always challenging scheduling wise, but there was a little bit more quality of life when there were only certain hours when paper could be filed. But that said, the burdens of small cases, if there was a reasonable number of them, were really good, where you weren't dealing with big teams of lawyers and big conference rooms and millions of pages of documents. So I really liked the scale of being at a small firm and working on smaller cases. And the downside of smaller cases is that to make ends meet, you either need more of them, or you need at least a mixture of types of cases, where some of them are more lucrative than others. I mean, I ranged from cases like wrongful convictions cases that settled in the millions, to clients that would sort of pay their fees each month, in cash. And those are very different types of cases. And, all the small wrongful arrest case where you do a couple depositions and see if there was a trial, or a small workplace discrimination case where there'd be, 4 or 5 depositions, and then mostly they would settle. Or big police practices lawsuits that would take many, many years, but it could ultimately be worth a lot more money. And the business model of making a mixture of cases work is challenging. And also at a small firm, right? You want to be working for lawyers that are really good and that can mentor you and teach you. And anytime there's a small firm, it's more dependent on the handful of partners who are experienced and sort of bringing in the good cases, and it all depends on their judgment. And if the partner that was sort of the key to the firm retires, then sometimes those firms, are no longer a firm, or the lawyers go off to other places. And so it's less stable than a really big firm, where if you have, 100 or 600 partners, like, so what if a whole group of lawyers moves to another firm? It doesn't matter. The firm has, 850 lawyers left. And so just smaller firms, they don't hire in the same routine ways. It's more informal. There may be a longer partnership track, but the rewards can be that you can really understand a complete case. You can do so much more early on. Really, the only other way you can get lots of trial experience, and it's really the best way to get lots of trial experience quickly, is to be a criminal lawyer, whether a prosecutor or a defense lawyer. But if you're doing civil work like I was, then being at a small firm is often the way to go. But it certainly has its challenges. It doesn't pay as well, and just the financial model of those firms is just always riskier.
And then my second question is, can you kind of describe your sense of how the civil rights work that a small private firm would be doing differs in the day-to-day from the civil rights from agency work? So like DOJ or State's Attorney's Office or the AG's office?
Well, in some ways it can be very similar. I have a friend who always, the former prosecutor who always teased me and one of the partners I work for, saying, "You guys are basically prosecutors. You should love prosecutors. You know, that's all you're doing is you're prosecuting, civil rights violations, basically." And because we're sort of private attorneys general, bringing cases on civil rights cases in a way on behalf of the public. In some states, there are much simpler mechanisms for, like, state attorney general's office, for example, to get discovery. And so they can move cases along sometimes much more quickly than you can if you're a private plaintiff. And so there may be additional tools and powers that public enforcers have at their disposal, which can be a really nice thing. And those offices typically have people who, are paid a salary for being there. They're not as dependent on, like, it's a government agency, so they're not dependent on contingency awards or fees or that kind of thing. Like, it's just sort of stable economically. They're not worried about making ends meet, which can be also a really nice thing. So more power and not having to worry about ends meet. That's really exciting. They can also sort of carry out a broader policy agenda than some small civil rights firms can do. And those policy agendas can change, of course, as well. So you can have a new attorney general, whether it's state or federal, that says, you know what, I actually think we're going to focus more on, whatever it is, like housing discrimination. I think we're sort of stalled in our work on voter protection, so we're going to shift people from that unit, right? So if they're doing, whether it's civil or criminal, if they're attorney general, if they're a prosecutor, they can adjust their enforcement priorities based on policy. And so it may sort of depend what the focus of that office is and whether it aligns with the kind of work you want to do, and that can change.
Great, thank you so much.
Any other questions from the group? Okay. Oh, Brandon, thank you so much for being with us this evening. I think it was a really compelling overview of your work, your research, as well as identifying some areas that our students might be able to pursue as they step more wholly into this space going forward. So thank you so much for being with us.
Yeah, my pleasure. Thank you all so much for having me.
So folks, next week we will be joined by Frank Straub, who is at the National Policing Institute. He'll be talking about averted school violence data collection and data collection more wholly as it relates to some of the work of the National Policing Institute. So I will be on travel, but still hosting the conversation as anticipated, which is also to say that next week I will have limited availability. So if you have questions, comments, concerns about your research assignments, please get them into me this week so I can respond in a more rapid manner with the response rate that I have established to date. In the meantime, I hope you all have a lovely, restful, or productive Monday evening, and I will talk to you soon.